All right, so the last module we talked a little bit about the idea of judicial review. Now we want to talk about this court system and the structure in the United States. So we have to really talk about the distinction between the federal court system and the local and state court system. So, only about 10% of all the cases in the United States are tried at the federal level, so there are state court systems. We're going to focus only on the federal court system, right? So under Article 3 of the Constitution, which is the one that deals with the judiciary, Article 1 is Congress, Article 2 is the President, and Article 3 is judiciary. Basically, it doesn't say a whole lot about how the court system should be set up. It says that there should be a Supreme Court of the United States and whatever court systems that Congress believes are necessary. So Congress has the ability to be able to alter the amount of courts, the types of courts, the number of judges, and so forth. And that's kind of one of their legislative powers. The only thing that we definitely have to have is the United States Supreme Court. And in the Judiciary Act of 1789, they basically set down the original court system, which has been expanded as we've grown as a nation and as states have gained population. But the way we can look at this is that we have 94 U.S. district courts, 12 circuit courts of appeals, and 1 Supreme Court of the United States, right? So all cases, most cases, I should say, start at the district court level, and every state has at least 1 district court. Basically, these are people that hear the original evidence of a case and kind of hold the original trial. Now, everyone is eligible for 1 appeal, so you can feel as though maybe somehow your rights were violated, maybe at some point the judge didn't allow evidence into the trial that should have been allowed, some kind of grievance that you have about the judicial procedure, you're allowed to appeal 1 time. And that would be heard at the Court of Appeals level. So there are 13 altogether, including the Federal Appellate Court. Now, after that, you're not entitled to hear anybody else hear your court case. However, the Supreme Court, of which there is just 1 in the United States, has the ability to be able to look at court cases from the lower courts and determine whether or not it wants to hear those cases. So the United States Supreme Court has what we can call discretionary authority to determine whether or not they want to hear court cases in any given year. And we'll talk a couple minutes about how that actually occurs. So if you take a look at this in geographical boundaries right here, you'll see that basically each area of the country or each region of the country has a different kind of appellate court system. So one of the most well-known in the United States is the Ninth Circuit Court of Appeals, which you can see here is out on the West Coast. It looks like it takes up about a quarter of the country, but in reality, if you take a look at some of those states, they're pretty low population, like Montana, Idaho, Nevada, and so forth. California being the biggest state there. And that's generally considered to be one of the more liberal areas of the country. On the other hand, the Fourth Circuit Court, which you see down here kind of in, kind of the lower mid-Atlantic into the southern states there, is considered to be one of the more conservative courts in the country. Now, the interesting thing in what happens in these appellate systems is the Ninth Circuit Court could decide something completely different than the Fourth Circuit Court. Let's just say, for example, gay marriage, right? One could say that there's a federal right to gay marriage, and the other could say that there's not a federal right to gay marriage. If you happen to live in those states which comprise the Ninth Circuit Court of Appeals, whatever they say is the law in your area of the country. If you happen to live in that Fourth Circuit Court of Appeals, whatever they say is the law for your area of the country. So you could actually feasibly, at any given point in time, have different systems of laws acting in different areas of the country. And that's where the Supreme Court basically has to step in and make a decision who's right and who's wrong. Right? Now, let's take a look at that Supreme Court. So there's nothing in the Constitution that says how many judges there need to be on the Supreme Court. So originally there's 6 justices. As you can imagine, 6 isn't very tenable given the fact that that's an even number, right? So, I know the founders originally kind of believed that the Constitution is the Constitution, everybody should decide unanimously, but if you got 3 to 3, that doesn't make much sense. So 1807 we moved to 9 justices, 63 we moved to 10, we moved after the Civil War back down to 7, and then ever since 1869 we've had 9 members of the Supreme Court. It looks very unlikely that that would change anytime in the near future. President Roosevelt, during the New Deal, attempted to be able to add a couple of justices to the Supreme Court. It was deemed to be an overly politically overt situation, and Congress said no. In today's hyper-partisan situation, it would be very difficult to believe that that could ever happen now, that we'd expand the size of the court. The average tenure for a member of the Supreme Court is about 15 years now, and we generally get a new judge every 22 months. So essentially every president over the course of American history has basically gotten to appoint 2 justices to the Supreme Court in a 4-year term. What we've seen in recent years, at least since the 1980s, is that presidents are nominating younger and younger people to the federal Supreme Court, whereby they might have been in the late 60s, years ago. Now we're seeing judges that are 54, 55 being put on the court. The reason being they can be on the court for 25 to 30 years and really influence what goes on there. So President Obama only got to appoint 2 members of the Supreme Court, and President Bush appointed 2 members of the Supreme Court as well, both of them serving 8-year terms. Right? So, how do you get to the Supreme Court? Well, there are two ways. Basically, there are 2 types of decisions: original jurisdiction and appellate routes. Right? Courts of original jurisdiction are the ones that actually hear the evidence for specific cases. Most of the time, the Supreme Court will not hear a case right off the bat unless it's an absolutely immediate thing that must be done in the interest of national security. In some cases in which states are filing suit against each other, the Supreme Court can hear that off the bat as well. Most of them come through what we call an appellate route. In other words, you start at the district court level, go to the appellate court, and then you petition the Supreme Court to hear your case. And the Supreme Court then looks at these potential petitions and decides which cases it wants to hear. Again, the Supreme Court has discretion over those appellate cases that it wants to hear. Now, how does it determine what kind of cases it wants to hear? Well, we apply something called the Rule of 4. Now, I don't think this would be too hard to understand what this means is. Guess what the Rule of 4 applies to? Yes. 4 people have to say they want to hear the case. So 4 out of the 9 justices have to say yes. Now, we won't spend a whole lot of time getting involved in this, but why do they determine that they want to hear a court case? Well, some of it's legal and some of it's political, right? So I mentioned before that there might be cases in which different areas of the country, different appellate courts disagree on whether or not the Constitution covers certain rights. And you can't have different areas of the country operating under different constitutional interpretations, so the Supreme Court would hear those cases. There may be some instances in which the lower courts have taken a precedent, in other words, basically the decisions that have been made before by the Supreme Court, and they've determined that those precedents no longer hold true. And now it's up to the Supreme Court to either tell those courts that they're wrong or to overturn their own precedent. Right? So sometimes the lower courts basically say we don't agree with what the Supreme Court said 50 years ago, and in those cases the Supreme Court hears the case again. And then finally, there are some topics, particularly when it relates to technology, where the Supreme Court has yet to rule on some specific area of public policy. Right? A lot of this has to do with, for example, virtual reality and various other things related to that. Those are not things that the framers ever really thought would be, could even conceptualize, right? And now there are new issues that arise that the Supreme Court has to take up. There are a couple of political reasons as well. The U.S. Solicitor General is part of the Justice Department. Solicitor General is the person that argues cases before the Supreme Court on behalf of the federal government. And when the Solicitor General would like to take up a case or request that the Supreme Court hears the case, they're more likely to listen to that case because they realize that it must be an important constitutional issue. Another thing is something called an amicus curiae brief, which is Latin for friend of the court. and the amicus briefs are filed on behalf of individual cases by interest groups and law schools and law professors and various other people asking the court to hear a specific case. And these amicus briefs can be instrumental in kind of persuading members of the court to hear a case if enough people say that this is relevant. And then finally, each individual member of the Supreme Court has its own, has their own kind of interesting avenues of constitutional law that they like to focus on, whether it be First Amendment, corporate law, whatever. There's certain cases that are just more interesting to some members of the court than others, and that might attract them to wanting to hear those cases. Now, they've decided to hear the case under the Rule of 4, right? What happens now? Well, this is very interesting. So basically, they get written arguments from both parties, and neither one of those written arguments can surpass 50 pages, right? So they don't want some huge mountainous volume of stuff. 50 pages is the max of citing legal doctrine and why the Supreme Court should decide on their side. The justices read through that, come up with their own questions, and then you hear what are called oral arguments. And it's very interesting. Basically, the whole thing takes an hour. Each side gets 30 minutes, and that's it, right? 30 minutes for both sides to make their argument before the Supreme Court. Now, that doesn't mean that I get to stand up here as the lawyer for the one side and go on and drone on for 30 minutes. I can have a whole prepared speech, and I get up there and I talk 30 seconds, and a member of the Supreme Court says, well, I got a question about that. And then they ask you a question, and you might get through your 30 minutes and not really have gotten anything that you wanted to out, but they keep asking questions back and forth, right? And they ask them to find out what you think, but they also ask them kind of to get points across to other members of the Supreme Court as well. So it's really interesting. And you know, they spend a lot of time preparing, lawyers spend a lot of time preparing for these questions. One time I was at a meeting with the National Association of Attorney Generals, and attorney generals oftentimes are the ones that argue cases on behalf of their own state before the Supreme Court. And NAG, as they're called, for the National Association of Attorney Generals, actually has experts that kind of come in and play the part of individual justices of the Supreme Court. They're very well versed in the personality of individual members of the court, and as a consequence of that, they know the types of questions that will probably be asked by members of the Supreme Court. You never completely know, but they know given the past history. That way, you can train yourself to kind of anticipate some of the stuff that may happen, but you can't fully anticipate anything. And you may not get all your points in, and hey, that's life. You know, it's not fair. You get 30 minutes and you're done. All right. So what happens after that? Well, then they decide the case. All 9 justices, if the court is fully staffed, go into what's called a conference committee. No one is there with the exception of those 9 justices. And the last justice to be appointed to the Supreme Court acts as the secretary. So, you know, for example, up until Trump's presidency, we would have seen the newest Supreme Court Justice, Gorsuch, will now become the secretary of the conference, right? They sit around, they argue, they say, this is what I believe, what do you believe, how should we decide on this case? They take kind of a little caucus of what's going on here, and maybe 5 people say, I'm going to vote to overturn this, 4 people say it's constitutional, right? Then we decide who's going to write the opinions of the case. Chief Justice has the right to be able to decide to write for the majority, or they can assign it to somebody else, right? So let's just say we have this example of a 5-4 split, right? People write an opinion, a legal opinion, about overturning or not overturning a law. Then they circulate these opinions. And I might take a look at it and say, well, you know, I originally said that I would side with the majority, but if you guys in the minority include a couple of extra lines here about what I'm thinking right now, I'm going to flip my vote. I'm going to vote your way, right? Now, it would be smart for those 4 other people to say, maybe we won't get everything that we want, but at least we'll be in the majority in this case. We'll give that other judge what they want. So in the opinion writing situation, there can be cases in which people's votes flip from one side to the other, right? By the nature of the arguments that are being made. So they circulate their opinions. There can be any number of drafts that are taken to get the thing right. And then finally, they have a final vote, and then that opinion is released, and we know the outcome of that court case. Now, just mentioned the opinions released. What does that all mean? Well, there are essentially, or can be, let's put it that way, there can be three different types of written opinions. The majority opinion is what we call the official opinion of the Supreme Court, and it carries what we would call precedent, right? What's the importance of precedent? Once the Supreme Court argues or creates an opinion, every other court in the future will then go back and look at that opinion for guidance as to how they should decide. And judges do not take overturning precedent very lightly, right? It's very important to stick to the legal rules of the game, and the majority opinion constitutes what is called precedent, right? So it doesn't necessarily have to be 5-4. Say, for example, only 7 justices hear the case and it's 4-3 for whatever reason, that's the majority opinion. But that's the one that carries precedent. Now, let's just say again we have this 5-4 decision. What happens to the 4 people that didn't get into the majority? Does anybody listen to them? Well, yeah. They write their own opinion. It's called the dissenting opinion. They say, we disagree with the majority in this case because of these reasons. And they write them down as well. Now, that doesn't have any precedent, right? Because these people were not in the majority. They don't get to decide what the law, how the law is going to be interpreted because they weren't the majority. But in the future, people can rely on those arguments and attempt to be able to get the court to do something, right? So, if you have a 9-0 decision, there wouldn't be a dissenting opinion. But if you have an 8-1, 7-2, 6-3, 5-4 decision, you're going to have a dissenting opinion. Now, there can be multiple dissenting opinions, and there can also be multiple discussions of the majority opinions. And I don't want to get into too much detail here, but they are called concurring opinions. So I could be in the majority and say, all right, I agree with what the majority said here, but I also think that there are a couple of other issues that they didn't touch on that I think are important. But I can't persuade those other people to vote my way on this, so I'll just write my own opinion. Again, this is just a way for me to be able to state my case outside of the majority opinion and the minority opinion. They carry no force of precedent. All right, so majority opinion, precedent, right? The only thing that really counts in this court case. Minority opinion, those people who are not in the majority get to also state their case, but there is no precedent here. It doesn't really count towards anything. And then a concurring opinion is just saying, I'd like to add something on to the arguments that have already been made in either the majority or the minority dissenting opinion. Right? Now, the final thing here is that we can say that the court has a lot of power vis-a-vis the states, the local governments, Congress, and the presidency by virtue of its ability to be able to engage in judicial review. However, this is not an unlimited power. Congress has its own checks on the judiciary, so there are a couple of things that they could do. First of all, Congress could decide to alter the Constitution, right? So a primary example of this is the income tax, which everybody, of course, doesn't like to pay. But that was passed in the early 1900s, ruled unconstitutional by the Supreme Court, and then we got the 16th Amendment. Congress said, oh, all right, you're going to rule it unconstitutional? Well, you know what we're going to do? We're going to change the Constitution. Can't rule it unconstitutional then. So Congress could alter the Constitution. A second thing that they can do is basically take the power over the court's ability to be able to make decisions in certain areas, right? They could say basically you don't have the right to be able to judge cases related to taxation. We'll do that, right? They could expand the size of the court. Remember, Franklin Roosevelt tried to do that in the 1930s. The Supreme Court was basically overruling some of his court cases when it came to the New Deal, and he said, well, you know what we'll do? We'll try to expand the Supreme Court size, and that way I'll appoint the people, and what do you think they're going to do? They're going to say yes. Well, that could feasibly have been done, right? And then finally, the government could refuse to implement the decisions of the Supreme Court, right? So, for example, in the case of Brown versus Board of Education, the states really dragged, and the local governments really dragged their feet on integrating schools in the South, and they tried to get away with that. Eventually, the federal government stepped in and stopped that. But really, when you think about it again, there is no real power that the Supreme Court or any court system has to make anybody do anything other than the force of its opinions. And we're lucky enough to live in a system in which basically both other branches of government adhere to what the Supreme Court says, but there could be a time in which they just say, we don't agree with your opinion, what are you going to do about it, right? So that's the end of our discussion of the court system. We'll move on to the next branch.